Bismillahirrahmanirrahim. My name is Zahir Hassan and this is my YouTube channel. This is our second session on the topic criminal trial step by step under the provision of Code of Criminal Procedure. And if you recall my first video, we ended up logically concluding the trial. The trial was concluding, resulting the conviction of accused persons. One of them was sentenced to death. Two of them had to undergo the imprisonment for 10 years, right? And I made it clear, if you're not satisfied with the verdict rendered by the learned trial court, you still can impugn it, you still can challenge it on the next forum, and mechanism of appeal is there. If you are accused person, if you are an accused who has been sentenced to death, or any kind of a sentence has been given to you, including the fine, whatever, right, you can challenge it in the mechanism of appeal. And if you are a complainant and you are not satisfied that adequate sentence wasn't given to the accused persons, then you have got the right to challenge that order in criminal revision, asking for the court, appellate court, for the enhancement of the sentence, right? Now we move forward. The chapter which provides the mechanism of appeal is chapter number 31 of our Code of Criminal Procedure, and section 404 to 431 deal with the operations in the mechanism of appeal. And before we should proceed further, I would like to quote a quotation. It is said that trial lawyer is a kind of an artist who fills in the colors on the canvas of a criminal or civil case, and appellate lawyer or lawyer dealing with the appeal is like a critic who is appreciating the true colors, meaning and the import of the evidence recorded in the trial court. Chapter 31 deals appeal in a 7 way. Number 1, appeals from orders, appeal from sentences, appeal from order of acquittal, appeal abatement of appeal, arrest of accused pending appeal, and suspension of sentence pending appeal, and cases where no appeal lies. Well, it is noteworthy here, before we should proceed further, that appeal is a continuation of a trial. It is not something, an independent concept, in our legal system. It is embedded with your criminal trial, and it is extension, continuation, and we will see a couple of provisions right now we'll be discussing, which amplify this idea that appeal, although is stricto sensu is not a trial, but yet it is an extension of trial. We have to digest this notion that appeal has a nexus with the trial, unbreakable nexus. It's another form of a trial, yet it's not a trial stricto sensu. What is the definition of appeal? Appeal means formal removal of a case from inferior to a higher court to ascertain the legality and sustainability of a judgment. So let's anatomize chapter 31, section 404 to section 431, section wise, right? Section 404, which opens the chapter 31, says no appeal lie from any judgment or order of a criminal court except provided for by this code. It means it's clear that not every order of the trial court, if you are not satisfied with it, they have passed an order, trial court has passed an order. Every order is not appealable, but this doesn't mean that you don't have a remedy. If it is not appealable, then revision lies. If even revision doesn't lie, there is no provision which is helping you out. The Code of Criminal Procedure has failed to give you a remedy, then Constitution of Pakistan gives you ample rights. The chapter of fundamental rights, the concept of fair trial, newly incorporated article in our constitution, cumulatively give you some right to impugn or call in question any order of any court, criminal, civil, or quasi-judicial tribunal, whatever, So we move forward by skipping section 405 to 407, and let's examine section 408 and 409. Section 408 and 409, as a matter of fact, explain that orders all the 3 classes of magistrate, which I mentioned in my first lecture, that there are 2 classes of criminal court given in Code of Criminal Procedure. Section 6 defines it. One class is the class of magistrate, this class of criminal court, and the second is the court of session, right? Section 408 and 409 explain that all the orders of the three classes of magistrates shall be impugned or challenged before the session court, and in this respect notification dated 21st March 1996 was issued for Punjab, right? And this is what is in the vogue right now. Section 410 tells if the court of session is the trial court, then sentence given by the session court will be appealed before the high court. Section 411A, expounds a very interesting picture that if high court is exercising its original criminal jurisdiction and it gives a sentence to an individual, the same is to be challenged or impugned before the same court comprising of the two worthy judges of a high court, right? And this sentence can be challenged on the point of law only, right? Section 412 says when no appeal lies when a accused pleads guilty, it is definite, but the accused has pleaded guilty, it's a discretion of the court to give him whatever the treatment. The trial court can sentence him or can give him any appropriate sentence, whatever, but still you can challenge if the sentence given after accused has pleaded himself guilty, if the sentence is harsh, severe, or the quantum of sentence is not what it should have been, or the law provides a sentence of an offense and some other sentence has been given, right? Still you can call in question, but otherwise no appeal lies. Section 413 says no appeal lie on the petty matters. Three occasions have been explained as far as petty matters are concerned. Number one, if high court gives a sentence and doesn't exceed 6 months. Number two, if Supreme Sessions Court sentence that doesn't exceed 1 month, and if magistrate gives a sentence doesn't exceeds 1 month and fine of 50 rupees. In this eventuality, no appeal lies. And section 414 to 414A only deal with the summary trials in the matters like price control offense, etc., and no appeal lies against that these orders. Now I skip section 415 to 415A, and now I come to very important and very important section in our code of criminal procedure, that is section 417, which deals appeal against acquittal. All class of magistrate and session judge as a trial, if it acquits the accused in a trial, the appeal under section 417 shall lie to the high court, and its limitation is 60 days, remember, right? Within 60 days you have to file an appeal. Section 417 has to be read as section 427 of Code of Criminal Procedure. Well, section 427 says if appeal against acquittal has been preferred, in which the leave has been granted to examine whether the verdict of the trial court was healthy, was correct or not, and the appellate court has a discretion under section 427 to issue a warrant against the accused, bring him into the court, summon him into the court, and could be enlarged on bail, or could be send him behind the bar. There are two, so section 427 deals with this situation. 418 section discusses appeal may lie on question of fact or question of law. So the very important question of the day, किस ग्राउंड पे अपील होनी चाहिए? देयर आर टू ग्राउंड्स. एक ग्राउंड होगी या सीरीज ऑफ ग्राउंड्स होंगी which deal with the questions of law, whether the learned trial court has properly applied the law, and the second segment is facts, if the facts were properly elucidated by the court, whatever. Section 419 discusses that appeal should be in the form of a petition and accompanied with the order appeal against. ये question pleading से मुतल्लिका है. We will also take up this question some other day, but suffice it is to say, when you prefer an appeal, it should be in the form of a petition, right? इसका एक format है, and it should be accompanied with only an impugn order. Section 420 bestows upon the convict locked in a jail to prefer as an appeal through jail, and 421 to 422 deal with the summary dismissal of appeal or notice of appeal. So appellate court has still got the power to examine the material of the appeal and can dismiss summarily, or Other way, it can issue the notice to the other party for formal hearing of that appeal. This is what the statute says, but in my understanding of law and the case law and the practice of our court, this statute is actually of the colonial days. Maybe the colonial powers wanted to still retain something in their hands, didn't want to give the advantages of legal cover to the subjects in those days. But today law is entirely changed. When you prefer an appeal, definitely the other party is given a notice, right? Summarily, it is not discussed. I haven't seen anything like that. Therefore, my interpretation is that always appeal, when is preferred, the other party is given a notice, right? Section 423 deals with the powers of appellate court. Very important section. And if I peruse this section, I spontaneously say that this section is actually accused specific and conviction specific. What are the powers? Number one, requisition of the record of the matter. Number two, may dismiss the appeal after hearing both the parties. Number three, in case appeal is from a conviction, can reverse, modify, alter, set aside, remand, or maintain the sentence. Next power which it exercises, may direct the retrial of a case if it is appeal under section 417, or appellate court himself can acquit the accused. And then the next power is appellate court under this chapter cannot enhance the sentence. So this power is not reserved with the appellate court. It's very important that appellate court, while dealing with the appeal, cannot enhance the sentence. For enhancement, you have to actually invoke other provision of Code of Criminal Procedure, and that is criminal revision, which we will be take up after this session, inshallah. Next section of law, which is very important, section 4, suspension of sentence. It happens in our legal system due to the backlog of the cases. High Court sees if the sentence is short, suspends the sentence, and the criteria is short sentence, 3 years, 5 years, even some eventualities a 7-year sentence if it has been given to an accused person and its appeal is pending in the High Court, the sentence is suspended. But anyhow, what is the written criteria given in the statute? They say when the imprisonment is of 3 years and appeal has not been decided 6 months, sentence will be suspended. When imprisonment is of 7 years and appeal has not been decided for 1 year, sentence will be suspended, accused will be bailed out. And when sentence is of life or exceeding 7 years, appeal has not been decided for 2 years. So this is the written criteria. But it is noteworthy here that this concession is only available to that accused person whose appeal has not been decided, not due to his own good self or conduct of his counsel, but due to the backlog of the cases or any act of the court or any act of the adverse party. The learned counsel on behalf of the complainant does not appear, and appeal is fixed for many occasions, and certain specified time has passed as given in the statute. Then your right accrues. Thus, the court can enlarge you on bail by suspending your sentence, right? But again, another very important proviso which is there, which I'd like to share with you, that this relief of suspension of sentence not available for the accused convicted under the provision of anti-terrorism laws, or who they are desperate, dangerous criminals and hardened criminals. This discretion will not be exercised for these accused persons. Now I discuss section 428. After skipping some sections, I come on section 428. It is regarding taking of further evidence at appellate stage. When I said appeal is a continuation of a trial, actually I had also in my mind section 428. For section 428 says that learned appellate court, if sees this is befitting case for taking further evidence, it can itself not record evidence, rather would direct the subordinate court who has decided that matter to record further evidence. That learned court, the trial court, would record that evidence following the mandate of chapter 25 of Code of Criminal Procedure, which discusses how the evidence has to be recorded in presence of the accused, etc. It's detailed. We will discuss it in some separate session, inshallah. So provision of chapter 25 of Code of Criminal Procedure would be applied while recording the evidence, and then it will be certified, will be remitted back to the appellate court, and on the basis of that fresh evidence recorded by the trial court, appellate court would decide the matter. But if it is befitting case. Section 429 says if the judges are equally divided, then there are two judges in say murder case, they are equally divided, one says acquittal, other says conviction, then the matter will be referred to the referee judge, right? The referee judge, after hearing the parties, will decide the matter. Now after skipping section 430, I come on the last section of Code of Criminal Procedures, chapter 31st, and that is section 31 of Criminal Procedure Code. It says abatement of appeal. In case accused dies, there's the demise of accused, all the appeals abate. But the case law on this subject, which I have seen and gone through, is somewhat different. Appeals were even decided after the demise of accused, because some offense is like a stigma which carried by the deceased even after his death and his family. Therefore appeals were decided. I hope you have liked today's video, and if you have liked, do comment, and if you want more videos to be heard, and then subscribe my channel and press the bell icon. And I hope you have appreciated whatever we have submitted, and in order to learn more for myself, I need your comments. Do give me comments. Thank you very much. Assalamu alaikum.